This is Michael Cowen, and welcome to Trial Lawyer Nation.
You are the leader in the courtroom, and you want the jury to be looking to you for the answers.
When you figure out your theory, never deviate.
You want the facts to be consistent, complete, and credible.
The defense has no problem running out the clock. Delay is the friend of the defense.
It's tough to grow a firm by trying to hold on and micromanage.
You've got to front load a simple structure for jurors to be able to hold on to.
What types of creative things can we do as lawyers, even though we don't have a trial setting?
Whatever you've got to do to make it real, you've got to do to make it real. But the person who needs convincing is you.
Welcome to the award-winning podcast, Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
We're going to start a new feature on this podcast. It's Ask Michael and Mallory Anything. If you have anything you'd like to ask either Mallory or me, we're going to start doing an episode every couple months where we're going to answer your questions. So just send them in to me at michael@cowenlaw.com, and Mallory and I will answer them. Anything from, legal strategy, marketing management, anything else in life you want to talk about, we'll be glad to talk about it with you. Again, Ask Michael and Mallory Anything. Just send us an email. We'll be glad to answer your questions. Welcome to today's Trial Lawyer Nation. I'm here with my partner, Laura Pazin Porter. Laura, how are you doing today?
I'm good. And you?
I'm great. We just got out of trial, and we're going to talk a little bit about it. But before we do, I want to thank our sponsor, Law Pods. Law Pods, you and I just finished working with them. They produce this podcast. They make it so easy because they sit with us and make sure we look as good as I'm capable of looking, which isn't necessarily that good, but that we sound as good as we can. They do all the editing. They make all the clips for socials. They're just a joy to work with. So if you're thinking about doing a podcast, I highly recommend Law Pods. So Laura, we just finished a trial, lasted a week and a day. It just resolved right before closing arguments yesterday. How are you feeling?
I feel great. I think it was the best outcome. It was everything we could have wanted, and it's guaranteed by settlement. So I think that's great.
Yeah, so let's talk a little bit about the case. Just because it was a confidential resolution, let's not mention the names of the parties or the company. And of course, we can't mention any numbers or any non-financial terms in settlement, but we can talk about the case. And because I think sharing some of our trial experiences will be good for our listeners that want to try their own cases. So give me a little bit of background about the facts of the case itself.
So the crash happened about 6 o'clock at night. It was dark. An 18-wheel driver decided to back the tractor trailer across a highway at night, blocking the middle lane, both lanes in one direction, and the shoulder of the roadway in order to back into a business. And our client came along and could not see the trailer in enough time to completely avoid the crash. And there was a collision, and it was fatal.
Yeah, in these cases, they're righteous, but they can be tough because they're righteous because when a tractor trailer is backing across the roadway, it is very difficult for oncoming traffic to see the trailer in time to stop. And there's two real reasons for that. One are the headlights. So when you see headlights, your eyes adjust. It's not that you're blinded, but your eyes adjust to the headlights. Your pupils kind of shrink, and it's hard to see something behind the headlights because you just see the lights. The other thing is the reflective tape on the trailer. It's really effective at a 90-degree angle, but it's not very effective at the shallower angles that a trailer is at. And so the reflective tape is pretty much invisible. So until you get close enough where your headlights actually hit the side of the trailer, in this case it was a white trailer, you don't see it. And so unfortunately people crash into trailers backing across. I mean, reasonable trucking companies don't let their drivers do that, but unfortunately there's a lot of unreasonable trucking companies out there that don't tell their drivers how dangerous it is. The drivers think because of that tape that they can be seen just fine. And so they, this happened, and unfortunately because of another problem called underride, that when the truck, ours was a pickup truck, but a passenger vehicle hits the side of a trailer, it just slides right underneath. So our driver was going between 18 and 25 at the time of impact, but he was still got injuries that killed him a few minutes later. He didn't die instantly, unfortunately. But this is a really, really dangerous thing to do. But unfortunately, the police officer investigating it, he didn't realize that. So what did the officer do in this case?
The officer actually blamed our client for the crash, saying that the 18-wheeler had the right-of-way because he was already in place. Putting aside the fact that this was a 60-mile-an-hour zone, that our client was going under the speed limit, the officer did not evaluate what speed, if any, what rate of speed our client was traveling at, did not consider whether the client could see the trailer, didn't take any of those things into consideration. He simply did an investigation and did not do a recreation or anything to try and figure out the speeds involved or anything like that.
Yeah, he testified he did not do a reconstruction and wouldn't have been qualified to do one had he wanted to. I think a couple of things that really made it more challenging is one, since our person had passed away before the officer got there, and even when he was there, he couldn't really talk because the injuries were so bad. But the truck driver could, and the truck driver gave the police officer a story about 3 other vehicles coming to complete stop, but and then our client coming. Yeah, that story turned out not to be true, and we know this because we had the lapel cam from the police officer, so we know what the other truck driver told him, and then we had some surveillance video that caught the crash, and we also had, we deposed those witnesses. We just found out that what the driver told the officer wasn't true, but the officer didn't know that, and I think he relied on that a lot, and it just kind of formed his initial opinion. And the other issue we had is there was a surveillance camera from a nearby business that caught the crash, but the camera was in night vision mode. And so what you saw on the camera, everything you can see super clear, but that's not what the drivers saw. And we got that from one of the actually witnesses that stopped after our client saying, that's not what I saw. Like the reflective tape is like lit up, glowing in the surveillance camera. But he says, I never even saw that tape. I didn't see anything until the tractor, the trailer got the white of the trailer. I never saw the tape. So, I think those are challenges because the police officer, the driver tells him something, he believes him. Our driver obviously could not give his side of the story because he was dead. And then, he sees the surveillance video. He's inexperienced. He doesn't know it's a night vision. And so he thinks that, it was really obvious to see this tractor trailer back across the road. Other vehicles were able to stop, not realizing they didn't stop till well after the crash. And then our client lit up the trailer with his headlights for them. But, he didn't realize all that. And he was pretty ineffective, I think, when his deposition was shown at trial. But his entire analysis, the defense part was a 4-minute direct, and we did a 9-minute cross. And talking to the jurors afterwards, I don't think that any struggles we had with the case were because of the police officer's testimony. It seemed like they all realized he didn't do a very thorough job of investigating and didn't really move the needle for them. But, because the defense was so heavily relying on the fact that, the officer found us at fault and didn't find them at fault, they took a real hardline position in pre-settlement and even negotiations during most of the trial. The offers were really, really bad. So that being said, what did we do to try to overcome this, the police officer, starting off behind the 8 ball where the police officer was against us?
Well, the witnesses, the on-scene witnesses were really important, and they are the ones who also gave us the information that our client did not die instantly. Yep. Their testimony was pivotal in providing the facts of what was going on, what could be seen, what could not be seen, all of that. And so I'm so grateful to the witnesses for being willing not only to stop to help in this crash, but also being willing to give a deposition so that we can get the evidence that we needed in this case.
Yeah, I think the witnesses were double-edged swords. They were really good for the conscious pain and suffering. They were really good for you couldn't see the reflective tape, but they were deposed 3 years after the crash, and their recollection of how the crash happened, and how soon they were able to see the trailer was not helpful for us. The driver of the next vehicle to stop, thought he saw the trailer before our person, before the crash. And that he was actually ahead of our person at the time that he saw it. It was actually physically impossible. We have the surveillance video showing that, when our client crashed, it was 8 seconds later when he came to a stop. We just know from the laws of physics, how the time distance with our expert, that there is no way that he was actually in front of our client at the time that he saw the trailer. Our client, I mean, it has to have been post crash when he saw the trailer, like after our client's headlights lit it up on right before the crash. So, we had the laws of physics with us, but we also had an eyewitness that his recollection, and he was super friendly, but his recollection 3 years later, there were some facts that were not good for us. And when we talked to the jury afterwards, the two defense jurors were really locking on to his story as to why they were pro defense. I think one thing that really would have helped us had the jury, because we had the vast majority of the jurors for us, that would have helped, is that he had a passenger in his vehicle who gave a statement to the police on the time, and you did a good job. When she gave her deposition, they were husband and wife at the time, and she, pretty much testified along the same lines that he did. But on the night of the crash, she actually said they were traveling behind our client, which is more consistent with the physical evidence and the fact that I wouldn't say impeached because she was a friendly witness, but you brought up the inconsistency, like what you told the police on that night was that you were behind. And I think that should have won the day for us. And even if our client could have stopped, it's still super dangerous to back a tractor trailer across a 60-mile-an-hour highway at night. We also hired experts. I think we could not have done this case without experts. And I think, we had a really good crash reconstructionist who did a lot of work to reconstruct the crash, did something called a night study to show how hard it would have been to see the trailer. And we'd had a prior problem in another case of getting in not a recreation, but a demonstration we had done, a case that Mallory and I tried last June, where we were actually able to get it in, but we had a big fight because the expert picked a different kind of truck with a different kind of transmission system. None of that should affect how air brakes work. They made a huge deal about it. So this time we got the exact same model pickup truck, the exact same model 18-wheeler. We even changed out the lights in the pickup truck because our client's son had put on better lights, LED lights that were better than regular headlights. Got the same kind of trailer, went and we had to do it in a parking lot, not a road, because we didn't want to kill anybody, but went and recreated, what our client would have seen at different distances. But despite doing all that work, the judge wouldn't let the photo. She let the experts talk about it, the study and what they found from it, but she did not allow the photos they took that showed what the view would have been and how hard it would have been to see the trailer. And that was a challenge because I think seeing is believing. I think if we'd been able to show those photos, our case would have been more obvious. But what did we do when the judge, we've done all the work, we've created these incredible visuals, they were going to be the center point of our case, and the judge says, well, I don't think those are fair because, everything's still in real life, the vehicles were moving, so I think the view may have been different, so I'm going to not let you admit them. How did we handle that?
We just kept going. We of course didn't ignore the ruling. We abided with that, but the expert could testify to the night study. And so we took that and used it to the best of our ability,
Yeah, I think one of the quotes I gave you was from the character Dory in Finding Nemo. Just keep swimming. I think I actually whispered that to you at trial at one point. And we have our judge I like our judge. I really respect our judge, but we were in Deep Red, Texas, and our judge was a former prosecutor. Admittedly did not have a lot of civil experience, and when there was a close call, she was leaning more towards defense. That was her philosophical background, and so we did not get. We had a lot of rulings that did not go our way. Critical rulings went our way. Actually, she allowed us to present gross negligence. She denied both summary judgment and a directed verdict. So, she was very fair. And I think every decision she made them on what she thought the law was and what she thought the facts were. There was no favoritism. There was no bias. But her leanings, her predilection was pro-business, she's just, like I said, a red state Republican Texas judge. And so I think our mindset was so important. When you're going to get some adverse rulings, I think I shared my mantra with you. The judge is a good person. She is applying the law, what she believes to be the law, to the facts as she understands them. We're going to trust her. We're going to accept her rulings, and we're going to trust it. Even if we disagree with the ruling, she's coming from a good place. She's not trying to screw us over, and just continue to treat her pleasantly and with respect. And I think that went a long way, because I think as the trial went on, I think we got more and more of the rulings, because we would have case law and they would often have rhetoric.
Yes. I think that's a really important mindset to keep, because at some point things may not go your way, and it's, do you want to use your energy to be upset or, steam over that, or do you want to just keep pushing forward? So I think it's a positive mindset to have the approach that you had, and I think it's beneficial for you and your team in your case, because you can't, let hurdles sidetrack you. You just have to keep pushing forward with that positive mindset.
Yeah, and none on that, I think our first witness was our trucking expert. And while I generally don't love having a paid expert as our first witness, I thought it was really important to establish what the rules were for truck drivers and trucking companies first, and then to establish that the rules don't just come from our expert, but there's sources for the rules. In this case, we really relied on the Commercial Driver's License Manual and on the U.S. Department of Transportation Preventable Accident Manual. And that was really where we were sourcing our rules. And again, that was a challenge, because usually my expert can talk about the rules and then show how in his opinion, the defense broke the rules. In this case, the judge allowed us to present the rules, but did not allow our expert, with respect to the driver, to specifically opine whether the defendant driver broke the rules, because he wasn't both a reconstructionist and a truck safety expert. And so again, rather than getting mad, we just said, okay, well, I have lots of little mantras. I do something called the Miracle Morning every morning, and part of that is I read affirmations myself. So I added an affirmation for the trials. I'm going to win this trial no matter what. There is no other option. And I just say that. So no matter what the judge's ruling is, I'm going to find a way to win. And so we just showed what the rules were. With the expert showed where they came from. She did allow us to say that with respect to training the company didn't comply with the rules, but we couldn't say that the driver didn't. That was fine, because we trust the jury. And if we can show what the rules were, and we wrote them down on our giant pad, then we can later on show that they were broken. So I think that worked quite well. I don't think that we were actually hurt by not having the ultimate opinion from the expert.
Right. I think it was helpful to have him be the teacher of what are the standards, what is required. And so I thought that was effective.
Then when it came to, the liability, like I said, it was mainly, the eyewitnesses, very nicely discrediting the police officer just by showing what he didn't do. And he agreed he didn't know whether a person had time to stop. He didn't know whether a person first could have seen the vehicle. So I think he was pretty cooperative on the cross. And then, of course, talking with all the eyewitnesses about what they saw. We also took the deposition of the owner of the property that the tractor trailer was backing into. And I think that was helpful, too, because the owner testified, we didn't tell him to back in. There was no reason to back in. He could have gone in forwards had he chosen to. That, really showing this was an unnecessary danger.
Right. I, too, thought that was really important testimony for the jury to be provided.
Then jury selection. What word would you use to describe jury selection?
So it was, challenging because some of the questions that we would, take for granted from other cases were not allowed here. And so, again, the same mantra that was held throughout, the judge is a good person. She's doing what she thinks is right. And so I respect that. And so we will comply with what she feels is appropriate, or rules is appropriate. And so you just keep swimming.
Yeah. For example, one, we were not allowed to ask questions about whether the jurors could even consider, awarding over $10 million in compensatory damages. We couldn't even say millions. We could say, could they consider allowing money for this element of damage, but we couldn't go into any kind of numbers, which, while I respectfully believe that the case law allows us to do that, it doesn't really matter what I think. It matters what the judge thinks. And she made a ruling, and we respected it and moved on. Doesn't mean you don't worry about preserving, appellate issues sometimes, but in this case, the biggest thing was to try to get a good jury. The other thing is I was planning on doing a more inclusive voir dire, and two things happened. One, I was having objections sustained to questions I could normally answer that would allow us to try to create our tribe. The other is, I think my two words to you after jury selection were rough crowd. We had a rough panel. We had people that we hadn't even described all they knew is it was a truck crash and a death, and there were money damages, and people were calling it a shakedown.
Money grab.
A money grab. I think that was the one judge, the one juror the judge would not strike for cause, who said his initial thought was it was all a money grab, and he would probably be leaning towards the defense, but he could try to set aside his biases and be fair. And so again, I had to go just listen non-judgmentally to keep it going, and we changed to a for cause. And the good thing is, as bad as I kind of felt after jury selection, because all these people saying all these horrible things about our case in front of our client, we ended up with a pretty good jury because we got so many of those people off for cause. And then luckily, the ones that we couldn't get off for cause, the judge did hardships afterwards. And they all had one juror was like, well, I got a calcium scan. It's really bad. And they say I have to see the cardiologist on Thursday. Well, Judge, we have to care more about this juror's health. We need to let him go.
Yeah. So some folks had conflicts, vacation planned, and so luckily we were able to, have some of the folks excused for those
and I
reasons.
think I really liked the jury we ended up with.
So did I.
But until we got that jury selected, it sure was a scary experience. We also had Jessica Brylow, trial consultant. She's been on the podcast before. She came and helped us pick the jury. And I will tell you, that is so much help, because when I'm sitting there talking to jurors, it's so hard to keep track and keep notes of who said what. And when it came time for the cause strikes, she told me what to argue in every one. She had great notes. And then, frankly, when it came time to choose who to strike, I'm exhausted after doing it. I don't remember who said what. Definitely can't be listening to people non-judgmentally to get them to speak, and at the same time trying to evaluate who I want to strike. And so having that professional guidance, someone who's a jury consultant who does a lot of research, helping us choose who to strike, I think was invaluable.
I agree. And it was good, even those of us who were, they're also taking notes, just to have another person with that, specialty, just to verify, what our thoughts were. That was good.
Yeah. Then we moved on. So you did damages, I did liability, except for I did our psychologist. Why did we have me do the psychologist?
I'm not sure. I did think our psychologist was important to have there to talk about the types of damages and the grief that the clients had. They, not everyone is fully aware of how the loss has impacted them. And so I felt her perspective was important to further prove, the mental anguish claim of our clients.
Yeah, I think it was also very helpful to have her testify, because it took some of the pressure off our clients to talk about all their grief. They still talked about some of their grief, but there's a certain standard you have to show in Texas to keep mental anguish damages. You have to show substantial disruption to their daily routine. You have to show, severe mental anguish. And having the psychologist be able to evaluate them and tell their story for them. And that way they could spend more of the time talking about the positive stories and what a great person he was, what a great relationship there was. I just think from trial strategy. And if I remember right, I think I presented her because, one, I have a degree in psychology, so I know the psychology stuff pretty well. But the other is I had put her on at trial before, and I had a comfort level with her that we decided that it would be better for me to do that one witness. And then I called the driver adverse and the vice president for safety from the company adverse. They were both live. What did you think about those?
I thought they were good. I think it's important, especially with the driver. He is in smaller stature, and I thought that you did a good job of cross-examining him, but without being overbearing. Because he is smaller in stature, you don't want a jury to sympathize with him. And so I felt like you were mindful of the appearance, both, physically as well as verbally, sensitive to those issues of making sure that things, you cross-examined them, but weren't overly harsh.
Yeah, and it didn't help that he was a little hard of hearing, so he asked me to speak louder. And so you always want to be David, not Goliath. And when I'm 6'4", and he was probably about 5'2", 5'3",
maybe 5.
maybe
I'm not
5
sure.
foot. He was not a tall guy. And and I'm in my poor guy, and his suit didn't fit him right, and it would have been and I actually have some sympathy for the man. I don't think he intentionally killed it. And I told him that in front of the jury, I don't think he intentionally killed anybody. I think he was really poorly trained and really just didn't know any better. He didn't know how dangerous what he was doing, because the company, and I wasn't allowed to say this at trial by the judge, but this had happened before. The company knew people could get killed and knew that this was dangerous, and they never told him, and then they put him out on the road. So I actually had a lot of sympathy for him, but especially with the speaking more loudly, I just said, well, I want to treat you with respect. Please, if my tone is incorrect, please let me know, because I want to be respectful to you, and just kind of let him hang himself by saying. Now I still had to impeach him because he tried to change his testimony from what he said in his depo, and he tried to come up with excuses. But I think we were able to lock him in and show that what he was saying was false and what he was doing was dangerous, while still being very respectful to him and not just getting. And he would have been easy to beat up, but I don't think that would have helped us with the jury.
Yeah, and he was hard of hearing somewhat, but also seemed to have somewhat of a speech impediment, and so sometimes. So I just think that you have to be mindful when you're cross-examining someone, with that dynamic.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
The other thing I noticed when I was impeaching with his deposition, he was having trouble reading some of the words. And so I don't know if you noticed that or not, but I started reading them for him rather than asking him to read to the jury, because I did not want to embarrass him. I wanted to impeach him, and I wanted to show that he had no business driving an 18-wheeler on a public highway, but I didn't want to humiliate him as a person, like by yelling at him, getting in his face, showing that he had trouble reading. So, just trying to, what I wanted is I wanted to make the jury mad. I didn't want to beat up on him, and I wanted the jury to hear and have the effect of, okay, this lawyer is being perfectly reasonable, but what the other side's position is very unreasonable, and they're taking zero responsibility for something that's really dangerous. And they gave the driver a safety award for that year. The crash happened in December, and they said, well, he did nothing wrong, so we still got a safety award that year, and that was a huge part of our case. It's like, if you parked on the side of the road, they have a no sitting duck policy. So he was parked on the shoulder with his triangles out, his flashers on, and it was broad daylight. They'd fire him because that's too dangerous. But you can be blocking all the lanes of oncoming traffic at night for a minute and a half, cause a wreck, someone's killed, and they give you a safety award. And that really resonated with the jurors that were for us.
It did, and with everyone who's heard, the case, it's just unbelievable that he would be provided a safety award.
Yeah, but hopefully this case makes up for that. So you did, you put on the testimony of a family friend. This family was an interesting family because they wouldn't let us list their spouses. We got one family friend, but they were very resistant in our bringing other people in their lives into the case. They really didn't want to go to trial.
Right.
It's just the defense. At mediation, they were willing to take about 25% of my valuation of the case, but the defense wouldn't offer it. And right before trial, the Sunday before, the Monday before, because we picked a jury on a Tuesday, they were willing to take about 40% of my valuation of the case. But again, luckily the defense wouldn't offer it. And then, when we finally got done, we can't say the number, but it was greater than our demand when we started the trial. But luckily the defense did not let them settle the case before, because they really weren't happy about trying the case, and they really did not want their family members and friends brought into it because they just thought it was too stressful and too painful.
Right. They really do, value their privacy and did not want to, have their family, go through a trial. And so when they did, when the parties did end up taking the stand, I think it helped that they had seen a family friend go before. I think it gave our plaintiffs confidence that they saw it happen and he did fine and he nothing happened to him, So I think it gave our clients more ease when when it was their turn to take the stand. I also, I talked to them about how when they took the stand, we were going to celebrate the deceased and wanted to share with the jury who the deceased was, and that was the focus that we should have. And so I think that gave them, it lightened their load, so to speak, that they could do that.
I'm going to talk a little bit about your trial journey. So you have participated in trials, but you had not put on an expert or a client. Is that right?
So years and years ago, I had put on a client, but it was so many years ago, I almost don't count it,
Yeah. So, but you put on the medical exam. We hired a medical examiner to determine whether there was conscious pain and suffering, and also cause of death was obvious, but we're in Texas and there's appeals, so we wanted to make sure we had testimony of that. What is it like? You haven't done it before. It was a fairly easy one in that they originally had an expert saying there was no conscious pain and suffering, but by the time you finish you do the deposition of that expert, and by the time you finish, you got the expert to agree with our expert, and they ended up not calling theirs because you got their expert to agree, yes, there was conscious pain and suffering.
Right.
And so, but it's still always a little nerve-wracking to do something for the first time. So first of all, what were the feelings and emotions like? You're getting ready to put on an expert. You've not done this before. You got the jury, you've got me, you've got your associate, your paralegal, so you got an audience. What are you feeling?
I just told myself, you have done this before. You did it by deposition. You have done this countless times before. No different. Now you just do it with, the more people live in the room. And it was helpful. It wasn't, the first day,
Yeah.
we had been in this room since Tuesday, and I was doing the direct on Thursday, and so had lived in this room for a few days by then. And so at some point you just put your head down and do it, and
Yeah.
so that was really my focus.
And you did fine with the expert, but there's something different about I'm going to try to put into words. Your direct examination of our two clients, the two sons of the deceased who testified, was the most magical experience I've ever had in a courtroom. Sorry.
Well, I thank you for that, because I know you have a lot of experience.
I
and
have very high standards, and I've tried cases with Mallory Peacock, and I've tried cases with other great lawyers, and I am just telling you, there was magic that happened, and they told. I mean, you had two people that did not want to be there, that were scared to death. That one of them, he wanted to testify in English, but it was a little bit of broken. He really struggled with coming up with the words, but the emotion that came out, the stories, and it wasn't just sadness. You started both of them with the joy. You're getting family photos, and they're telling stories, and they're smiling, but you just had this like beautiful glow to you. You had a smile. Your eyes were like lit up when you're talking about all the good times, and like we could all feel like the love and this great person. And then when you went to the sad times, the judge had to like take breaks to pass Kleenex out to the jurors. What clicked in you? How did that happen?
I just wanted to share with the jury the love that this family had for each other, and for their dad that they lost in this crash, and just wanted to share that story that each of the plaintiffs had, and just wanted to honor him in what we presented to the jury. And so that was really the goal. Wanted to share funny things that he would do.
Yeah.
If the son was cooking dinner, the dad would say, make sure you don't burn it,
Yeah.
So he had all these quips. He was just a really funny person, and I wanted to share that. I just wanted to share all the good things about him, and just felt that was really important for the jury to know how special he was, and to really honor him, and also to show that while they may have other father figures in their life, there is no one who will take this man's place that passed away.
Yeah, just like the widow. Although the widow did remarry, which is a challenging fact. There's nothing bad about it. She lost her husband. The poor woman, she didn't drive. She couldn't read. She was dependent on him. It was a 40-year marriage. And then the husband, he was faithfully married to another woman who also died of cancer around the same time. And they're two grief-stricken people who turned to each other for love and support. And
they met at church, and both church-going families. And so just to show how special and individual the decedent was, and just to give honor to that.
I think you could have never, I don't know how much time you spent with the clients, but you could have never done that magic if you didn't put the time in to really get to know them and for them to really trust you to guide them through this experience. I think it ended up being a really good experience for them, but experience they didn't want. I mean, they had no desire to go testify. They,
Yes.
like, we can't get this thing settled. Can we please not do this? This is too painful. I don't want to do this.
Yes.
Tell me
They
a little
were
bit
resistant.
tell me a little bit about how you got to know them and how you got the stories from them.
Well, back when we were doing discovery, some clients, it's easier to get discovery responses from than others. And this one, it was harder. So I had to go to their home in order to get the discovery responses that we needed. And so just continuing to have that relationship, they had my cell phone number, which, that way they could call me. Both of the adult sons work, and during office hours was not a good time for them to reach me because they were working too.
Yeah.
And so I needed to give them that access to me so that if they had a question, they could call me. And they did not abuse it. They are great, hardworking guys, family focused. And so they truly would only call if they needed something. And it was usually me calling them.
Yeah.
But they knew it was me. And so they would take the call. They always took the call or called me right back. Very responsive in that way. But, just continuing to visit with them. And, we wanted to try and get this resolved for them sooner rather than later because we knew how resistant they were. But they also wanted to honor their father and were not going to do something that would not be reasonable.
Yeah.
And so, I think just going through the process, and with them, it deepened the relationship. And also their character. They are funny. They are a funny, loving, good family. And so, in that way, it was fun to share because they had the stories already. They had the quips because that's just, how they relate to one another. And so I'm glad, I do consider them extended family.
Yeah, absolutely. They're special clients.
They are.
And even like we picked a jury on a Tuesday morning, our Tuesday. Even that Sunday and Monday, it was an hour from our hotel to where the clients lived each way. And we still went to their homes. And, some people say, well, it's 4 hours out of your life just to driving plus going to their house. You couldn't just Zoom or have them come see you. But I just think there's something about being in someone's home where they're comfortable.
I agree.
And I also don't think I could have gotten nearly the testimony you did if I put them on. Because I did not have that. I mean, we get along great now, but I did not have that deep relationship you had.
I think it was just, through the course of the case, I listened to them. They listened to me. I would, communicate with them about, where things were, and just had that deep trust relationship. And, told them the good things, told them the bad things, and so we had that level of trust. And so, they, as time went on, would open more with me, and I'm grateful to them for sharing so that we could present the case that we were able to present for them.
I think something magical happened in the parking lot the evening before they testified too, because they had been reserved, very stressed out. They'd been watching the trial, but I think somehow watching us fight for them, seeing the trial go through, all of a sudden we saw smiles and they were telling happier stories, and it just it seemed really like something broke through. It's hard to put into words. Can you elaborate on that?
Sure. I mean, I think two things happened. One, they heard more of the testimony that we were able to obtain from the witnesses. There's one witness in particular who was who had stopped at the scene and was with their dad in his last moments. And I had thanked the witness by deposition, when she was sharing what she had done. And the family immediately wanted to reach out to her to thank her because they had thought that their dad had died alone in the vehicle. And here there was a witness who was there in the vehicle with him, praying with him, holding his hand. And that just meant the world to them. So I think that they valued that. I also think that them seeing the family friend, the before and after witness, as we call it, see him testify, I think it took some of the scariness out of testifying. And so I think just seeing us fight for them, hearing that their dad wasn't alone, and knowing that they could take the stand and it be okay.
Yeah.
I think that together just, made them feel more at ease and like they could do this.
Yeah, and as scared as they were, and much as they didn't want to do it because they thought it would be so painful, I really have, in a wrongful death case, I think there is a healing portion to trying a case. And I think having your fellow people listen to you, acknowledge that through their verdict that something happened that was wrong and that your loved one had value. Now, I think sometimes when they lose a wrongful death case, it could be like losing the loved one all over again. But I think in this situation, we've seen the difference. I think there's some healing that happened from them going through that process. How did you feel about settling? And we settled, I guess, Saturday afternoon. We're going to come back and do closings Monday morning. There were no new offers after jury selection, and then I get an email Saturday morning saying, "Can you talk?" And so I had a feeling, I know how I felt, but I want to hear how you felt first.
Well, I was cautiously optimistic, because on the one hand, you want to, see if you can make a good recovery for the client, on the other hand, I really thought we could get a good verdict. And so I did, we were right there before closing. And so, I was thinking on that Saturday of all the closing argument ideas and had started, writing some of those down so that you and I could visit, because I wanted to help being part of that process. But then, in thinking of something, though, that could, be more of a guaranteed recovery for the clients, I didn't want to lose sight of that, of course. And so, was open to hearing, what the defense might be willing to do.
Yeah, it was very much of a roller coaster for me because as much as you never know for sure, I did really feel like we were winning that case. And, when we talked to the jurors afterwards, with 75% we were winning the case. I don't know how it would have turned out after deliberations, but my gut feeling is that it would have been fine. I mean, because I think we saw the start of a deliberation in the hallway after the trial. By the time we got out, the defense lawyer was already talked to them, and they were going back and forth. But we had a good 9 out of 12, and so I think it would have worked fine. I also knew that the clients were happy with the number, but I can't say what it was, and I wish I could. But before, there was a period of time between when the defense reengaged settlement talks, and they made a proposal, a number, and it was clear they had more. And I said I had to meet with my clients before we could respond. And plus, you want to show no hurry.
Mm-hmm.
But one of our clients was at work, and we wanted to wait till they were off work and they could all be together before we talked to them. I asked about something non-monetary, whether the company would be willing. I can't say what it was, but whether they would be willing to make a change that I think could save someone else's life. And that really changed the evaluation, because if you're risking money, it's one thing, but if you're risking money and the chance to save future lives, if whatever it was, I can't say, but it made me feel very different. And then the clients were so happy and they were so relieved, but I'm very proud of what we did in that case, and I wish they would let me say what it was, but we did something that I'm super proud of that wasn't just money in this case, and I'm hoping that it does good in the world. And, afterwards, we went back to thank the jury on Monday, and we got to talk to some of the jurors afterwards. And again, we had a couple that we didn't have, but we had a lot of them that kept talking to us, followed us to the elevator, or wanted to hug our clients. That was just a beautiful thing. But then we all had lunch with the family, and all of a sudden, all these other people that didn't let us meet kids, spouses, and everything all show up. The widow's new husband, everybody, and we just had a great time. But how relieved they were, and it wasn't about the amount of money; it was about honoring him. It was about honoring him, about his death not being in vain, about someone not being able to get away with doing something unsafe and killing him. I think it was just really a beautiful, beautiful thing, and. Y'all go to trial. It's fun, and it is meaningful. Even when you resolve it, during the trial, you make meaningful changes in people's lives, and frankly, the money does go up if you're trying the case well.
Yeah, and to be able to make a lasting impact, to hopefully save other lives and have it be positive for the clients, all the way around. I felt like there wasn't anything more we could have asked for.
Yeah. I agree. Well, Laura, I loved going to trial with you. It was so fun. And if anyone asks, it's not bullshit. I really do have fun during trial.
He does. And thank you. I'm honored to have the opportunity to go to trial with you. And it was a great experience, a positive experience. And I'm ready for the next one.
Well, good, because we have one next month and one the month afterwards. Hopefully, at least one of those to go, and let's go have some more fun.
Yes.
But trial really, once you let go of the fact that you don't control the outcome, you don't control the rulings, and you just keep swimming and just try to, I said every morning, I think I told you all, my goal is to spread love and joy today, and even the judge rules against you, treat her with respect and try to share love and joy and energy, and same with the jury, same with the clients, even the other side. Trial can be fun while you're being effective. And I just feel that my life I'm a better father, husband, and son after going through this trial than I was before. I am being more present with my kids. I'm calling my parents more often. I'm putting down my phone and listening to my wife more because I saw what a wonderful human being this was and the legacy he left. And I want to try to do some of the same. And our decedent was such, he wasn't rich. He wasn't, didn't have a college degree, but he was an incredible human being, and the world is a worse place for losing him. But he did leave behind a legacy of love and an incredible family he raised, that he made the world a better place by living here. Well, thank you all for listening. Sorry that you're hearing us tear up every now and then, but it was a very powerful experience we just went through. I encourage y'all to do the same. Trials are fun. Trials are good for you once you get past that fear of losing and just get in there and let it rip. And like Dory says in Finding Nemo, just keep swimming.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.